not heard appeal in the matter of Bailey and Stonewall Equality and others.
Yes, something like that.
Good morning. Before I resume my submissions, my lords, my lady, there was one matter that was raised yesterday by the court, which was a reference to some findings the tribunal made about the extent of Stonewall's influence. It was Lady Justice Whipple who posed the question to me and recalled a passage in the judgment and reasons. My lady, I think the passage that you are referring to is at page 179, paragraph 355 of the funding.
I think I was thinking about an earlier passage actually, in the sort of the earlier body that deals with the evidence, where I mean I may have made this up, but I think I have read it. There was some discussion about what was being promised on both sides of the mutual arrangement, and in the event, I think I picked up that Stonewall hadn't done some of the things that it said it was going to do.
Yes. If I may, I'll come back to that.
Back at some point.
To pick up from where I left off yesterday, then,
Yes.
I had taken this court through the tribunal reasons and identified, firstly, the directions that the tribunal had given itself in relation to section 111, and made the point that it accorded with the suggested approach from each of the parties below. And then we had looked at how the tribunal had weighed the material in front of it, in particular looking at page 182, the passages that related to Mr. Metcalfe's evidence and explanations and justifications. In response to questions about findings that the tribunal had made, and in particular findings in relation to Mr. Metcalfe's email of the 31st of October, we had looked at paragraph 369 and paragraph 372, which in my submission set out the relevant findings. The balance of paragraphs 373 through to 379 indicate the way that the tribunal sought to weigh the evidence and the witness testimony that it had received in order to test the conclusions that it had come to. And my submission, as you heard yesterday, was that all of those matters that were taken into account were legitimate considerations for the tribunal dealing with the matter below. And they formed the basis of the conclusion set out finally at page 187, paragraph 390, that the claims against Stonewall do not succeed.
Can I ask this? In the email,
Yes.
supplementary bundle, pages 2 and 3,
Yes.
includes sentences. However, for Garden Court Chambers to continue associating with barrister who's actively campaigning, etc., etc.
Yes.
I trust that you will do what is right.
Yes.
The tribunal don't seem to say what they think that last sentence meant. Were there any submissions about it in writing which would show what the submissions were by either side as to what that meant?
There were written submissions and indeed oral submissions, my lord. I don't have them immediately to hand, and I at this stage can simply characterise the gist of the dispute between the parties as being that the claimant's position was that this was an obvious and direct threat, and the respondent's position was that it wasn't, for reasons which Mr. Metcalfe explored in his evidence. So the parties were polarised. The tribunal, in dealing with the email itself, do not focus on any particular passage in the email. I think that's fair to say. They do, in their consideration at paragraphs 367 through to 368, explore both the content and the proposed reading of it. And one sees in paragraph 368 that the tribunal acknowledge that the language of Mr. Metcalfe's email is language which could be read as a threat. Well, in fact, what the tribunal say is the claimant sees the statement that continued association with her put them in a difficult position as a threat that she should be expelled if Stonewall was to continue its relationship with Garden Court. And then they go on to say that is certainly one reading. Although not said explicitly, I think I must accept in paragraph 368, the tribunal appear to have concluded that it wasn't a threat. I say that by omission,
yeah,
because they don't, I think it's right that I acknowledge, say specifically that whilst it's one reading, it's not the correct reading. But in my submission, that is implicit,
yes,
in the remainder of not just paragraph 368, but the balance of the judgment.
And by that you mean wasn't meant as a threat?
Yes. Well, I say yes. I can't place myself in the shoes of the tribunal, but if it assists, the claimant below stated in very clear terms how she saw that email. In her witness statement, she told the tribunal that, to her mind, the email effectively told Garden Court to expel her from chambers,
yeah,
or face being vilified and ostracised by them. And that was the position that was advanced robustly by the claimant. She also said that Stonewall used their immense power and reputation to try to destroy her profession and her means of making a living. And she said that the Stonewall of today is a dangerous and vicious organisation. So I think that gives you a flavour of the way in which matters were put by the claimant below.
Was there evidence below as to how the recipients of the email understood it?
There was, to some extent. Clearly, that was evidence from witnesses for Garden Court. And I think that I am correct in recalling that in the judgment, although it may not be in response to this email, I just want to check before I raise
Yes,
it.
please do.
Thank you. think that all I can properly say is that the claim in respect of the complaint and its outcome, when it was considered by the tribunal in the context of the wider allegations of collusion and conspiracy, were rejected. And in particular, the tribunal made findings that the investigator had not allowed herself, or indeed been directed by anybody, in particular Stonewall. The passage that I was thinking of in relation to Ms. Khan, who was one of the heads of chambers, predates the email. So I can't,
No.
I think, pray that in aid. But what the tribunal do, however, is in their reasoning identify the extent to which Garden Court engaged with Mr. Metcalfe's email. They don't record the evidence or indeed their findings on how it was received. And in, sorry, I'm just reaching for the passage. In paragraph 376, one sees, and indeed the tribunal are criticised for embarking upon this exercise, one sees some exploration of how Garden Court saw the Stonewall complaint. But that, I think, is the extent of the consideration that the tribunal had give to that matter in their reasons.
So, Mbala, can I just pick up my Lord's
Yes.
question from 368? The tribunal acknowledges that you could see that letter as a threat.
Yes.
But it could be said, and the way I think I have read it, is that they, in the end, we know they conclude that it wasn't a threat, but
Yes.
they seem to say it was a mere protest.
Yes.
So they seem to be juxtaposing those two things.
Yes.
Mere protest. And then they go on, so it appears, I want to ask about
Yes.
377.
Yes.
In the tribunal saying it was mere protest, and for the moment accepting that that was a rejection of the claimant's case before them,
Yes.
so it's saying it's not a threat. How does mere protest fit in with the legal directions that the tribunal has given itself at 360 and 361? So just before we go to that, what I'm interested in is 377. Yes, it's but for, but then they say it's we talk about it being the occasion and nothing more, and that kind of fits in with the idea of being mere protest
Yes.
and not a threat that caused the events afterwards. They then say, was the letter an attempt to cause discrimination against the claimant? And I think we've all accepted that wasn't quite the perfect formulation,
Yes.
but maybe, and I'm not saying, please don't think I've anything, I'm just trying to make sense of this.
Yes.
Maybe that was taking the tribunal back to its earlier self-directions on the agreed common ground about the factors that you've looked for.
Yes.
And then they conclude saying no more than protest. So that could be taken to be their conclusion
Yes.
in answer to the legal question. But how does mere protest, if that is what they decide, fit in with the criteria at 360 and 361?
Well, in relation to that question, and I'm just turning up the relevant passages, without wishing to shy away from the question, the first thing I think that I must say is that the way in which the claimant advanced her claim below was that there was an explicit intention.
Yeah.
And
Okay.
and
Got that.
therefore, in considering what Mr. Metcalfe did, and the I was going to use the word intent, but that's probably not apt in this context, and the rationale behind it, I think one has to view that through that lens. And when the tribunal come to looking at the specifics of Mr. Metcalfe's email, they, I think, are reflecting all of the elements of the section 1.1, subsection 2 and 3 offences, for want of a better word, because they are asking, is it right that the but-for threshold has been crossed? But then they are asking, was this actually the cause of the basic contravention? So that is my
They seem to be asking, again, I mean, this is just, you
Yeah.
know, they're not here to answer for themselves all the way to their judgment.
Yeah.
They seem to be asking themselves in para 377 whether there was any sort of wrongdoing on the part of Stonewall, because that seems to be the reference. I mean, maybe, perhaps, I don't know. Was the letter an attempt to cause discrimination?
well, I think what they were trying to do there was to pick up the way in which the claimant had put the case, which is that it either was an inducement or an instruction, or it was an attempt to induce or to cause. That was the. I mean, I was going to say that the claimant had a number of alternative propositions that she advanced, and the tribunal are, I think, doing the best that they can to cover all of those off. But when they talk about an attempt to cause, I think that's what they're getting at. They're getting at the alternative bases on which these are.
So just to be clear, if we take 377,
Yes.
you would say the last two sentences are nothing to do with the preceding sentence, really.
No, I think they are, if you like, moving on to deal with the alternative
I follow.
propositions that the
So in
claimant
terms of the
advances.
causation case, the causing case,
Yes.
you've really got the first two sentences.
Yes. I mean, it really is the occasion of and no more.
So how does that, and it may be, I mean, it may be that we don't find it in, let me ask you, what is your case on that before us on appeal? Is your case that that was a sufficient conclusion to the section 112 and 1113 questions?
Yes. Because if one takes all of the findings which the tribunal have made in the round, one arrives at a position where one understands why the claimant did not succeed and why the respondent did succeed, because the tribunal in their analysis look at the sequence of events which led to the basic contravention, and they identified a number of matters which in their view were causative of the basic contravention and which did not relate to Stonewall.
So what are they saying in legal terms? Are they saying it's a sort of, there was an intervening act by Garden Court?
Yes, yes, by virtue of the procedurally deficient and discriminatory investigation conducted by Garden Court and the decisions that were made in consequence. Because one has to hold on to the fact that it was the outcome of the investigative process, not the investigation itself, which the tribunal found to be the basic contravention.
I mean, I do follow the way you put it, and that obviously fits conventional causation
Yes.
type language.
Yes.
And that seems to be, to my mind, the language that the tribunal is talking. But just to be clear, they obviously say there was but for causation.
Yes.
They say, I think, whatever 369 means, they probably say, look, Mr. Metcalfe didn't intend any consequence. do they specifically address, is it accepted that ignoring what Mr. Metcalfe intended subjectively, it was reasonably foreseeable, at least as a possibility, that the email would cause detriment to Miss Bailey?
I think in honesty, one doesn't see that finding in the tribunal's judgment and reasons. It is, I would say, implicit in their conclusion, but it is not reasoned out in a way that one might have wished for.
And when you say implicit, do you mean implicit that they didn't think it was reasonably foreseeable that it could happen? Or do you mean that it's implicit that they did think it was reasonably foreseeable that it could happen, but that doesn't matter because of the intervening act by government?
Well, that they didn't think it was reasonably foreseeable that the investigation outcome would be discriminatory.
And I follow that. Is it nevertheless, can one nevertheless go as far as to say that they didn't think it was reasonably foreseeable, or that it wasn't reasonably foreseeable, that there would be no detriment to Miss Bailey?
I think that my answer to that must be that the tribunal say it is not clear what Mr. Metcalfe was seeking to achieve beyond protest.
And I follow that, but that's a different point, because we're now concerned with what was reasonably foreseeable, not what Mr. Metcalfe subjectively intended.
The potential outcomes of the investigation were that all of the allegations could have been upheld. None of the allegations would have been upheld, and some of them would have been upheld. Those were all options, and it doesn't seem to me that there is any indication in the tribunal's reasons to indicate that they thought it was likely or reasonably foreseeable that the allegations would be upheld.
Can I go back to 360, maybe to put the same question in a
Yes.
slightly different way?
Yes.
If we just put a stake in the ground for the moment on the mere protest
Yes.
point, because I want to investigate. If you go back to the self-direction of the tribunal, these are the components that it would need to
Yes.
cover off if it was to look at Stonewall's liability.
Yes.
360 talks about the mental element required with a significant influence relating to claimant's protected characteristic. So question one to you is, what do you say, what is your case on whether Stonewall's letter was significantly influenced by the claimant's protected characteristic?
The respondent's case is that it was not a significant influence.
But it has, whatever they intended by the letter, it has to be a significant influence on the letter, because that's what they were complaining about.
Well, I suppose I draw back, because what I don't accept is that the letter was an effective and operative cause of the basic contravention.
But that's a different part.
Later.
I think, I'm sorry.
I mean,
that's what
I thought stage one of the analysis was the writing of the letter significantly influenced by the claimant's protected characteristic of gender critical belief. The answer to that is obviously yes.
That's correct, isn't it?
Whatever.
Yes.
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 Thought so.
Yes. Okay, so we've got,
After that,
Oh,
it gets
yeah,
more
sorry.
difficult.
all right. Can I come then, if you'll forgive me, to my question two, which
Yes.
is then when you look at paragraph 361, and I'm just trying to understand how this all works out. I think paragraph 361 is the notion of the conduct in question. So that's Stonewall's conduct
Yes.
subjecting the claimant to detriment. And claimant's case was that there was this enormous detriment because Stonewall had intended and in fact had procured and induced Garden Court to conduct this investigation, and that had landed up with discriminatory outcome. But if you just step into the world, the ET leaves us in, that was a mere protest. What on your case is the detriment to be attached to a mere protest by Stonewall? Is there any?
Well, my submission is that there is no detriment.
Okay. Why?
The investigation and the scrutiny of the claimant's social media activity and her real world activity in relation to her gender critical beliefs was ongoing. There was nothing that the email from Mr. Metcalfe did that added to that situation. There was already a consideration of how the claimant's stance on social media and in public impacted on the reputation of Garden Court Chambers and its status as a diversity champion. So the letter doesn't, in my submission, add any new elements to the existing detriment. And if I ask the question whether the claimant could reasonably argue that she had been been put to a detriment by Stonewall, I would
assuming the findings are upheld that by mere protest.
I would say no.
So just to try and wrap that a bit, are you back at 377? Is the reason you say no that although on a but-for basis the caused the detriment,
Yes.
one can't treat it in law as causing the detriment because of the intervening act?
Yes. And the actors in Garden Court, because there were a number of
actors of Garden Court.
Yes, because there were a number of individuals who did things, particular things, that led to the outcome, which was the detriment found.
I'm really sorry. I may be boiling this down a bit too much, and I may come to I may rethink it. But are there really two strands of thinking in here? One is that if you merely protest your own view in opposition to somebody else's view, that is an insufficient act to cause detriment within the meaning of section 111, subsection 2, reading in section 13, subsection 1. That's point one. Secondly, and alternatively, if what actually happens is that somebody else comes along, the intervening actor B, and they do something that's really discriminatory, it doesn't, it anyway rubs out anything that might have gone before, so the intervening act supervenes. Are they separate things or the same thing?
I suppose, strictly speaking, they are separate things. Now, and I think perhaps what I ought to do, first of all, is to make it clear that in my submission, what Mr. Metcalfe says about what he did in terms of his email was he was protesting and he was advocating. Those were, effectively, and I think the tribunal make that finding, those were the two sides of the coin. So I don't want to untether those two elements and simply look at protest, because I think, in fairness to the way in which the tribunal approached it, those were the findings that they made, and those were the activities which they identified from what Mr. Metcalfe told them in evidence. And I go back, where do I get that to?
The tribunal does say again and again it was just a protest, but you're saying, are you, that you think it was a bit more than that? Their findings it was more than they do talk about his advocacy hat.
Yes, they say that he
369.
Yes, they say he had his advocacy hat on,
and we understand to mean he was writing to protest and put the
case for transgender people. So that's what I mean by saying that there are two sides to the coin.
I'm not sure the second side helps him.
No,
in the sense that
that may be right, but I
if you're
mean, in the
advocate-
interests of
if
accuracy.
you're
I think-
protesting, well, maybe you're just protesting, but if you're advocating, you're hoping that something will result from your advocacy.
I'm not sure that that's necessarily the case. There is, and it's sometimes described as virtue signalling, but there is quite a lot of advocacy which happens because people want to state their position, not because they want to do anything in particular or have done anything in particular. And if I may
Because
say,
then there is this finding, I mean, you know, we're trying to make the best of it,
Yes.
372.
Yeah.
KM and Stonewall,
Yeah.
they weren't looking for any
Yes.
action.
yes, and I'm sorry to be so banal about this, but that is a finding.
So let's take that and just picking up my lady's first point,
Yes.
see where we go with it. So suppose someone strip away this case a bit.
Yes.
But someone makes a protest
Yes,
in circumstances where it is reasonably foreseeable that a recipient of the protest will do something detrimental to a third person, in circumstances where in making the protest you are significantly influenced by the protected characteristic.
yes,
Now, if in the event the recipient of the protest does the thing which is detrimental,
Yeah.
we'll assume it was a reasonably foreseeable thing
Yeah.
to do. Is that all right? Does A get off the hook because they were only making a protest?
not necessarily. It depends on the nature of the thing that A does. I appreciate that you've built in that the thing that A does is a cause of what B then goes on to do, but it does depend on the nature of the thing that A does and the nature of the thing that B does.
But no, I followed that. So we're back to causation.
Yes,
And I think that was my lady's second point.
I'm sorry.
So in circumstances where you make your protest,
Yes.
not intending anything to happen,
Yes,
but in circumstances where it is reasonably foreseeable that a recipient will do something detrimental,
yes,
and they do in fact do something detrimental, so there is, for the sake of argument, no break in the chain of causation,
yes.
then A is liable.
For are we talking now about subsection 2 or subsection 3? Because
I think I'm causing, because I'm not quite sure
Yes.
what inducing adds to anything, but we'll say on causing.
on causing, in those circumstances, then A would be liable.
Yes, I see.
Why? Sorry.
Because I thought built into the question was that the thing that A did caused B to do the basic contravention.
There's a but for in there.
Yes.
And on my Lord's question, there's a foreseeability.
Yes, and perhaps I had understood that there was a but for.
Yeah.
That there was a because of a protest.
Yeah,
I'm
because of
assuming that we're in the sphere of protected characteristics, so that there was a because of protected characteristics, and then there was something that caused B to cause a detriment to C. And in those circumstances,
That's just to recite the but for. I mean, we're back at
Well,
we're back at the whole issue about damage. What is the damage or detriment that if somebody makes a protest without expecting anything to be done on the back of that protest, accepting that it might be reasonably foreseeable that something will be done?
yes,
We talk about what.
yes, yes.
Why does that make A liable under section 1112? What's the damage that A is doing to C at that
Well,
point?
Perhaps I've not understood. If there is, if there is detriment. So my position in submissions was that in the circumstances my lady outlined, there would be no detriment. If there is a detriment to C, which is I don't know what it might be, but if there was, then clearly potentially C has a cause of action in relation to both B and in relation to A.
And when you say detriment in that case, you mean the end result?
Yes, the end result.
Yes.
Yeah.
So am I meant to be looking at as part of your criteria for
Mm.
section 112, what I'd call accessory liability.
Mm.
So A is liable even though B is the actor
Yes.
causing discrimination.
Yes.
Am I looking for some detriment that's caused by A in the actions of A? And does the detriment need to be at that level? I'd understood that was exactly what you were looking for, is some detriment caused by A's act that's then compounded by B's act, and that's why the whole thing brings A and B in together.
No, that with respect, my lady, doesn't
Right.
work, because the language of subsection 2 potentially encompasses a situation where A themselves is not in a position to do damage to C.
Exactly. They put somebody else up to it. That's what.
Well, yes, and I don't know whether it would be helpful, my lady.
Just
here-
no, can we just keep?
Yes, sorry.
You can look at anything you want.
Yes.
I think this is really important,
Yes.
if I may say so. And I haven't found either side's submissions yet to be quite. It may be me, but I just haven't quite got clarity on them.
Yeah.
Because I thought what we all established yesterday was that if you had an innocent C who hadn't meant any harm at all, but had been part of the sequence of events, so they fulfilled the but-for test, but
Yes.
in every other way,
Yes.
and maybe they'd done what they'd done because there was a protected characteristic in place, but they were, in layman's terms, innocent of any wrongdoing,
Yes.
that they would not come within section 1112. So what I'm trying to work out is why not? What's the dividing line? And what I thought the dividing line was that A had to do something that brought culpability upon them, and I thought that was that they had to do something that caused detriment or damage.
I
Might not
don't.
be right.
Well,
I
no,
might
yes.
not be right. That's what I thought. That's what para 361 was saying.
Sorry, let me just go back to it. Yes, I think that is what paragraph 361 is saying.
Why is it
No, I'm just
saying
looking
that?
at it, and what para 361 is saying in terms is that the thing that A does must cause damage to C.
Yeah.
Must cause C a detriment, to use its
I'm
language.
not sure about that.
Well,
That because of the alternative of attempt. Can you, like my lord and my lady, I really haven't made up my mind about this, and this is the heart of the case,
yes.
and it's worth spending time on. Can we start with the detriment we're talking about
Yes.
is what the tribunal described as detriment for
Yes.
the investigation outcome, paragraph 320, Garden Court upholding the Stonewall complaint.
Yes.
And now look at section 111,
Yes.
conveniently set out tribunal's paragraph 42, unless you want to go to another one. I think we can forget about instructing.
Yes.
This case is not a case of instructing. And as my lord said, that maybe no difference between induce and cause. But there's 112, A must not cause B to do in relation to C.
Yes.
1113, if that's different, which maybe it isn't, A must not induce B to do.
Yes.
Subsection 8, the reference in the section to causing or inducing a person to do something includes a reference to attempting to cause or induce
Yes.
a person to do it.
Yes.
So, as it seems to me, attempt may not be successful,
Yes.
but there can still be liability.
Yes.
And as for attempted murder, maybe nobody's killed or even injured, but there is still the offence,
My lord, yes.
attempt. Okay. So the tribunal ought to be making findings both as to whether Stonewall through Mr. Metcalfe caused or induced Garden Court to commit a basic
Yes.
contravention. Alternatively, whether Mr. Metcalfe was attempting
Yes.
to cause or induce.
Yes. And my lord, if I may, at paragraph 361,
Yeah.
that is what they do. They deal with
Indeed.
both causing and inducing and attempting to cause and induce.
And for an attempt, state of mind is critical, because if maybe the former criminal trial judge in me, and maybe it's not appropriate, but you can't inadvertently attempt to do something. It's a conscious it's a conscious act. You are attempting to cause or induce a basic contravention. And they seem to me to find reasonably clearly that Mr. Metcalfe was not attempting to induce contravention. But whether the email actually induced or caused the contravention doesn't seem to me to require any particular intention on the part of Mr. Metcalfe.
No, I mean the intention is simply to do the thing, whatever that thing might be. If one looks at the language of subsection 2, so it must not cause another to do in relation to a third person anything. So as long as A intends to do the thing,
His
then
thing, not B's thing.
yes, A's thing, then that is sufficient.
I haven't got that. Can you do that again?
Yes. So in terms, if one thinks about it in terms of outcomes, so with for example, instruction and inducement, there's a clearer path to the outcome that A might be seeking to achieve by doing the thing to B. In relation to causing, that pathway is less clear because one doesn't necessarily need to have a particular outcome in mind, so long as the thing operates on B so that B commits a basic contravention, then the allegation is made out.
I hear what you say. The thing that was done here,
Yes.
the anything, which is a basic contravention, wasn't the investigation, it was the mess up of it, it was the discriminatory aspect of the investigation. Was it?
Well, it was the outcome, as the tribunal found it. It was
Yeah,
the outcome.
Yeah.
So,
But it wasn't the fact that she underwent
no,
investigation.
and it was during the course of the tribunal, and indeed in her evidence to the tribunal, the claimant accepted that Garden Court was bound to investigate the complaints that were made.
So the question for us is whether Stonewall caused Garden Court to do that thing, which was the
So
outcome of the investigation.
yes, did Stonewall cause Garden Court to uphold parts of the complaint that were made in Mr. Metcalfe's email?
And
That's the thing.
And essentially your case is, what the tribunal must have meant is intervening act by Garden Court, they were right, or they were certainly entitled to arrive at that
absolutely.
conclusion.
Absolutely. And the I mean, all of the things that one might say about this tribunal decision, and of course there are many things that one might say about it, but one does have to be careful when one is looking at it now, because not only were there thousands of pages of evidence, but there was lengthy oral submissions and written submissions in opening and in closing. And this is, for better or for worse, a distillation of both the arguments and the tribunal's conclusions in relation to those arguments.
So I think what I'm very so I think what I've gathered is that you say it's not really a question of looking at whether Stonewall or a tortfeasor, whether they are the A or not, because actually they probably do tick the boxes. So they in a different case with a different tribunal, they might have been found to be liable.
Yes.
But I think what you say is the point that it just comes out in a different place in my analysis. That what really jumps out is the tribunal's view that the fault lay with GCC and not with Stonewall mere protest and all of that, and that's why GCC carried the liability.
Yes.
And you were exonerated, and that fits much better with an intervening act kind of analysis.
Yes,
rather
and
than
I'm sorry I didn't articulate it so succinctly, but in relation to the use of the language of fault, I think that perhaps helps to shed light on what it is the tribunal were looking for and what it is the tribunal found.
Can I just anticipate what I think Mr. Cooper will say in reply?
Yes.
But to my lady's point, rightly or wrongly, it's not a question of where primary fault lies. The whole scheme of Section 111 is that person B, in this case, Garden Court, is doing something wrong under the Act. That's the basic contravention. It's not an answer to a claim against person A, the alleged inducer of the basic contravention, to say that person B is primarily to blame.
I think my response to that is clearly the provisions anticipate liability on the part potentially of both A and B. So that is right to that extent. But in practice, when the court or the tribunal is considering what has happened, it necessarily has to decide what things did and did not contribute to the basic contravention. And there may be things that A did that contributed to the basic contravention, and there may not. And whether there is or not depends on the particular circumstances and the particular facts of the case. So I don't want to give the impression that there is a clear, bright line in relation to these issues. That I think would be wrong. But what I do say is that it is for the tribunal that hears the evidence and sees the witnesses to make that evaluation. And here that is what they have done. And in my submission, there is no basis to go behind that. A different tribunal may well have reached a different decision. That doesn't mean that the decision of this tribunal was wrong.
Unless they erred in law, and I suppose that's what we're scratching
yes,
at.
But in terms of that point, my lady, if the parties put before the tribunal an approach as to the way in which the provisions ought to be interpreted, and the tribunal adopted that approach, in my submission, it ill behoves either of the parties that agreed that line to cry against the tribunal's ultimate decision that they misdirected themselves.
I do follow the way you put it. At the same time, on the way we've been discussing it, it's really about the language of causation and intervening acts. And it's not obvious to me that you get any self-direction on that, or that the parties really helped much on that.
Well, I am pausing just to remind myself of the sheer volume of material
Absolutely.
that the
You had all
Employment
sorts of other
Tribunal
issues.
was faced with, in part generated by counsel for all of the parties. It would be wrong to suggest that every single conceivable argument was put for each side. That would simply be untrue.
On the contrary, well, it was what, a 4-week trial?
Yes.
Some characteristics of a world war, and we are very conscious of the fact we are focusing on a very small part of the case.
Yes.
That's not itself an answer.
No,
to,
of course.
appeal.
But what I think it does do is to provide some explanation of, to express a value judgment for a moment, the paucity of detail in the reasons on some matters, not on all matters, but on some matters. And I think that one has to have regard to, if you like, the trench warfare that was going on for those 4 weeks in the London Central Employment Tribunal, or in fact not in the tribunal, in various rooms around the country by a cloud video platform.
Yes.
And I know that this court will be very familiar with the caution expressed by appellate courts when one comes to look at first instance decisions. My lady, you made the observation yesterday that we're not to pore over this judgment as if it were a statute. And equally, the principles that apply, which say that tribunals sometimes express themselves in language that is not always apt and is on occasion infelicitous, but that does not mean one ought to presume that they have got it wrong.
I mean, in this particular case, on the hypothesis you're putting forward, the key sentence is the email was the occasion of the report, no more.
Yep.
Now, this isn't expressed infelicitously to fit your case,
No.
it's just not expanded on.
Well, no, but it's again, I don't want to repeat myself, but in context where
They had all sorts of other things.
they
to
had
do.
50, I mean,
Yes.
my lord, you saw the list of issues. There were 14 separate allegations in respect of the inducing, causing and instructing complaint against Stonewall, each of those involving a significant number of actors, all of which the tribunal had to somehow sweep up. So yes, it is short, yes, it is to the point, but I do say that it is sufficient.
So you say that sentence, the email was the occasion of the report, no more, means it's part of the history, but it's not the cause
Yes.
of detriment.
Yes. I don't think that I can sensibly say very much more about that. My lords, my lady, you've expressed a reservation as to whether inducing subsection 3 brings anything else to the party. In this case, I would acknowledge that it probably doesn't, but I would also caution that having chosen 3 different words, and there are elements of distinction between them, that it would not be right to say that there can never be a case where there is a difference. But like my learned friend, I thought very hard as to whether one could induce and not cause, and I'm afraid I did not come up with any examples. May I turn then just very briefly to what I wanted to say about the meaning of causation in a slightly more structured way, or rather what the test is in relation to these subsections. And I did want to just address my learned friend's point that the reading in of words to the subsections, so the reading in of the words because of a protected characteristic, which is essentially what he invites this court to do. that is not an appropriate or effective solution to the problems that all of us have identified, because if I understood his submissions, Mr. Cooper said, well, the purpose of the Equality Act is to counteract this dreadful evil and provide people who suffer with a remedy. And that's true insofar as there is a framework which imposes liability. But it's not a remedy for any act or omission. It's a remedy within the confines of the various parts of the Act. And Mr. Cooper commended his analysis to this court on the basis that it provided stability and cohesion. I think it's fair to say that he qualified that by saying in relation at least to direct discrimination. But the sense of cohesion and the sense of stability which it offers is, in my submission, illusory, simply because if one is asking the question, did, because of a protected characteristic, A do something which caused B to commit a basic contravention, one is still generally never the wiser as to whether there will be liability or not. And that's because there is an assessment to be made by a court or a tribunal about the nature of the thing that is done and the extent to which it causes the basic contravention. That is an exercise that always has to happen in order to be sure that there has been a contravention of the subsection. And so in criticising the suggested limit which Mr. Justice Bourne offered in the EAT, where he had recourse to the fair, just and reasonable assessment that's often used when one is considering whether or not to extend an obligation in tort or create an obligation, and so has a sort of solid pedigree, if I can use that expression. The criticism was that that was too uncertain. But my submission is that whatever the set of facts a tribunal faced with a claim in relation to section 111, certainly subsections 2 and 3, is faced with having to make an evaluative assessment, has to weigh up the evidence, has to make decisions about was and wasn't, and what wasn't effective or causative. And that is something, first of all, that courts and tribunals are well used to. It's what they do day in, day out. In terms of the kinds of things that might make a difference, clearly if there is someone expressing overtly, let's say, racist views or views which are misogynistic, then that might help move the dial when one's asking the question about, has A done anything that causes B? But it's not an answer to that question in and of itself, because if it were, what happens is that Mr. Cooper's but-for test is elevated above any other test for the purposes of making a decision about whether or not there has been a breach of the Act. And my lords, my lady, you will know that in the sphere of tort, there are a number of different ways in which causation, to use that phrase in its sort of normal meaning, is considered. It's not simply but for. That's been identified very many times as an insufficient test, serving simply to exclude or to narrow the field rather than to focus it specifically.
Can I just be clear that where on your case, what I'd call the QA factor, but the just, fair and reasonable,
Yes.
as well,
Yes.
where that fits in. So you say that that is part of what the court and tribunal should look at.
Well, I suppose my submission is that where a tribunal is faced with a case of this kind, it is what they do look at, whether they explicitly acknowledge it or not.
Is a way of looking at it that fair, just, and reasonable inform more particular principles that ought to be applied? So, for example, you say, well, a novice actus intervening act principle ought to be applied. Well, that's because it's fair, just, and reasonable that there should be a rule along those lines.
Yes, I think I would accept that proposition. What I would also say is that well, I was going to say that it depends on the nature of the intervening act, but
Yes.
but I know that it has a very particular meaning, but clearly the provisions of Section 111 absolutely anticipate that somebody intervenes and does something. So
Yes. And indeed, it anticipates that they will do something wrong.
yes,
Yes.
yes.
So these are all, because I mean, tort law has its fuzzy edges, let's face it. These are all, I mean, people have talked about as being sort of legal mechanisms or control mechanisms or whatever you want to call them, different ways of sort of looking at the same thing and just saying, and I think somebody somewhere talks about it just being informed common sense.
Yes.
That these are, we're nosing towards the same basic principles of
Yes.
just trying to make sure the liability falls where it ought to fall.
Yes.
Okay, which may not help very much, but my short point, my question that I'd written down to ask you is that you accept that Q8 does form part of the analysis, quite where it falls and so on is, you don't need to be too formalistic about it, I think is what you'd say. It's not like it's a separate component of the test, it just is part
It's
and
part of
parcel
the test,
of what
and
people do.
yes, and I of course acknowledge that in that case they were dealing with remedy issues essentially. So when they talk about a first stage and a second stage, they are ahead of us, so to speak. But in terms of looking at liability, I think the analogy with the analysis of two stages is still helpful, because there is this initial, if you like, exclusionary phase where one sort of does a but-for test and sticks one's finger in the air, and then there is the second, more evaluative phase where one weighs the various considerations and arrives at a view.
The various considerations being what? Sense of what's fair and just.
Yes, and I suppose one of the considerations might be, yes, I'm not sure if it's a separate consideration because what's fair and what's just would take into account whether there were any particularly egregious factors that occur in the particular circumstances of the case, whether there are a whole range of factors which a tribunal or a court would weigh. Intention, for example, might be relevant consideration. Having said there are so many, I now struggle to think of anything beyond intention. But yes.
Can I just pursue something? My lady mentioned intervening act,
Yes.
novice actus.
Yeah.
But here the claimant says, right, there's no intervening act. The accusation against Stonewall was that Stonewall induced or caused Garden Court to do basic contravention. So, for example, Ms. Harrison's part in the story is not an intervening act, it's part of what Garden Court did to the claimant. The tribunal has found amounted to a contravention.
I think what the tribunal, the way in which the tribunal characterised it was indeed that there were additional things that happened. So whether rightly or wrongly, the tribunal appeared to have considered that the, I'm going to call it, internal debate within Garden Court chambers between investigators and heads of chambers and all the rest of it, that took away from Stonewall any suggestion of fault. And that's where we get back to that the complaint was the occasion rather than anything else, because it created an opportunity in the same way, I suppose, that if one has a gas-filled barrel left in a field by somebody, that creates the opportunity for harm. But somebody else needs.
What the ET, as I read it,
Yeah.
they were. The point they were strong on was that the way this investigation was carried out was problematic. And I don't know, because I haven't quite got to the bottom of it, but although it might be said that Stonewall's action was reasonably likely to, I can't remember what the formulation is in that case with a case, but it wasn't surprising that it led to an investigation, or there was a reasonable foreseeability that it would lead to an investigation.
Yes, an investigation.
It was, what I understood the tribunal for saying is it was nothing to do with Stonewall, that Garden Court conducted that investigation in an unfair way.
Yes, I think that's right, because when one looks at the criticisms that are made of the investigation, they relate to, for example, failing to share with the investigator the claimant's representations. Now that's absolutely out of Stonewall. It's nothing to do with Stonewall, and was a conscious decision made by Garden Court chambers for whatever reason. And those are, and you.
So it was that, and it was the intervention in the process of people who should have stayed out of the process.
Yes, having
and
identified
talking up the
indeed
conclusions.
Yes.
And so on. That was the package that
Yes.
offended the Employment Tribunal.
Yes, and the tribunal drew the inference from the material that it had that part of the reason that those things happened was because two particular people had views about the claimant's protected beliefs. But again, that wasn't anything to do with Stonewall, and that's I think where the tribunal landed, that bad things had happened, but actually legal responsibility for them did not lie at Stonewall's door. Yes.
Sorry, just to
No.
finish the sentence.
Yes.
Legal responsibility did not lie because what Stonewall did was merely the occasion and no more.
Yes.
And you say the most comfortable analysis is what they were saying. Whatever part Stonewall played, it was supervened by the failings on the part of GCC.
Yes.
But there are other analyses we could use.
Yes.
We could use fair, just, and reasonable.
Yes.
We could use the liver damage analysis.
Yes, absolutely. And no, I think that I was trying to see if there was a better way to formulate it from my perspective, but I think that is the nub of what I say.
Now, we've been focusing on what seems to me to be the heart of the dispute. Are there any areas which you need to cover which you haven't?
My lord, thank you for the question.
That's not, please sit down.
No,
Yeah. By all means, have a look at your skeleton.
if I might. I think the only other matters that I probably ought in I ought to deal with are the suggestions made in terms of the consequences of whatever decision is made on this appeal.
Yeah.
And if I might just take a moment to do that. And before I do that, my lady, I have been very helpfully passed a note which identifies a
Sitting behind you.
Yes.
Where are we?
paragraph 79, page 105. I think that's the passage that you had in mind.
Page 105.
Yes.
Yeah.
So, excuse me. So, just going there to make sure that's the. Having spread out, I've now lost my place. Well, if I just turn briefly to the grounds of appeal, I hope that the way in which the respondent has identified its positions and the propositions that it has laid out are relatively clear. If they're not clear by now, it is my fault, and I apologise. But I've already made the point about the approach that one ought to take to the reasons. Some of the criticisms that are made in the grounds of appeal, certainly in relation to the test that the tribunal said that it was going to apply and its application, it said that we didn't know what it was. Well, clearly we do. Paragraph 360 tells us. And if that's right, then that is dispositive, at least in part, of grounds 1 and 5 of the appeal. In relation to Mr. Metcalfe's email and the conclusions that the tribunal made about it, there are findings at 369 and 370 which the tribunal made, and which, in my submission, respectful observation of the Employment Tribunal's particular speciality or specialism in a case which involved issues in terms of discrimination that they deal with day in and day out, means that you ought not to go behind those findings. The other ground that's canvassed, both in relation to causing and indeed inducing, is the notion that the Employment Tribunal were preoccupied with Mr. Metcalfe's subjective intentions, and as perhaps one might gain the impression that that came out of nowhere. But of course, it was the claimant's case that he had a subjective intention, and that was put in evidence by the claimant, and that evidence was then tested with the very many witnesses that came before the tribunal. So to see the tribunal dealing with that in some detail in the decision itself is not, in my submission, evidence or an indication of misdirection. It is the result of the way in which the claimant put her case and the narrative which she provided to the tribunal. And if there is no misdirection, and it's my submission that there is no misdirection, if the tribunal were wrong on the law, that's the party's fault. If there has been no misdirection, then we are left with a bare perversity appeal. And I know I don't need to rehearse what is said about those. So what I think we'll do in closing is simply to say that there is sufficient evidence from the material that has been placed before you in terms of the tribunal's reasons and the issues in the case, as well as the pleadings in the case, or some of them, for you to be satisfied that a permissible conclusion has been reached on the evidence. That exercise, the drawing conclusions from the evidence, is one which the first instance tribunal has. And there is no basis in my submission for any attempt to go behind it or to overturn it. As I say, a different tribunal may have reached a different conclusion, but that is nothing to the point. My lords, my lady, I feel I have tested your patience. If there are any questions, I'll do my best to answer them.
We've run out of ammunition. Thank you, Ms. Parlour. Mr. Cooper.
My lords, my lady, I'm going to keep my reply focused on what the court has identified as the part of the dispute. I'm going to attempt to bring as much focus to the way I put the case as I can, and in doing so reply to some of the points that my learned friend has made. Can I just start by framing this discussion by reference back to the way that the claimant's case was put to the tribunal in a nutshell, because it in fact might help to understand the albeit brief, but the structure of paragraph 377, which is a crucial paragraph. The way in which I put the claimant's case in closing was twofold, essentially, in relation to this particular action by Stonewall and the particular consequence by Garden Court. I said to the tribunal, if they were to find that Garden Court did discriminate, did commit a basic contravention by partially upholding the Stonewall complaint, then since the complaint was plainly, materially or significantly influenced by the claimant's beliefs, and since that that discrimination would be by definition because of the complaint, a result of the complaint, because it would be upholding that complaint, then that would be sufficient to establish liability. And that was on the basis of the same propositions I put to this court, that but for plus significant influence and the characteristics of discrimination are enough. The alternative case, which did rely on intention, was the attempt. So at that point we didn't know if the claim against Garden Court would succeed. So I said to the tribunal, if you don't uphold the claim in respect of Garden Court's decision on the complaint, then we say that the Stonewall complaint was an attempt to cause discrimination, and for those purposes we invite you to find that Kieran Medcalf intended to induce or cause Garden Court to expel the claimant or take other unfavourable action against her because of her beliefs. So it may be then that when you come to the brief reasoning at paragraph 377, that it's those two alternatives that are being reflected. The first two sentences deal with my primary case on the basis that the Garden Court were found to have discriminated, and then they ask themselves, was the letter an attempt, which they answer by reference to Kieran Medcalf's intentions. And so I think we really are left with the first two sentences as being the tribunal's answer to the claim having found that Garden Court did discriminate. And on any view, those two sentences don't answer the tribunal's self-direction at paragraph 360, which was entirely consistent with what I had submitted to them was the correct approach. And if they were introducing there the concept of an intervening act breaking the chain of causation, that was something they were doing off their own bat without anyone having suggested that that should be part of their considerations, or what the characteristics of an intervening act that breaks the chain of causation might or might not be. And certainly we haven't submitted that is something that they needed to consider or should consider. Ms. Omenbala, I don't think had either. So that's the structure within which the tribunal was looking at it, and they plainly didn't deal with it on the basis of their self-direction. But we are left with what they did say, and the question is whether what they did say is an adequate disposal of the claim as a matter of law. Can I deal very briefly with the point that arose in relation to the meaning of the final sentence of paragraph 369. This is slightly out of the core focus, but just so that you have my submissions in full on it. The question is, what does except perhaps a public denial of association with her views mean in terms of Mr. Medcalf's intentions? We've checked our notes. We can't find a passage in Mr. Medcalf's evidence that is reflected in that bit of the tribunal's reasons at paragraph 369. The bit of our notes which follow on from reference to him having his advocacy hat on record him saying that he was asking individuals to take action but didn't want to prescribe what it might be. So we can only infer that that final part of paragraph 369 is the tribunal's finding rather than anything specific that Mr. Medcalf said in evidence. And as to what it means, in my submission, it can't be a reference to Stonewall making a public denial of association with the claimant's views via the complaint, for a number of reasons. First of all, the whole of the passage from the start of 368 through to the end of 369 is devoted to the question of what Mr. Medcalf wanted to achieve in terms of Garden Court's response to the complaint. Secondly, the complaint was not a public statement. It was a private complaint to Garden Court. If Stonewall wanted to make a public statement dissociating themselves from the claimant's views, there was nothing to stop them doing it, and they could make a public statement to that effect. Thirdly, there is nothing whatsoever in the tribunal's findings to suggest that Stonewall was in any way associated with the claimant's views, or perhaps more importantly, that Mr. Medcalf thought Stonewall was in some way being associated with the claimant's views. On his evidence as recorded by the tribunal, what he was saying he was concerned about was the association of Garden Court chambers with the claimant's views and the potential impact that might have on people who were trans visiting Garden Court. Of course, our case was that there was no impact at all, but that was what he asserted was his concern. And so the final part of paragraph 369 in my submission only makes sense as a reference to the possibility of Garden Court making a public denial of association with the claimant's views. So what the tribunal is saying, he didn't have a specific aim in mind in terms of what Garden Court might do, except perhaps Garden Court saying publicly that they didn't agree with the claimant's views and dissociated themselves from those views.
And that wouldn't be a contravention of the Act.
Well, it might or might not, depending on the terms in which they said so.
Well, of course.
If they said so in the terms of in which Mr. Medcalf had expressed himself in his complaint, if they said the claimant's views are transphobic and bigoted and we thoroughly dissociate ourselves from it, that certainly would be a contravention of the Act. If they did no more than say, our barristers are entitled to their views and those are the claimants, they're not the corporate view of Garden Court, that wouldn't be a contravention of the Act. And in fact, the claimant agreed to a statement on the website you'll have seen from the judgment, essentially in those terms.
Yeah.
But that in any event is what I say is the meaning of that. But the court will have my point that it's all beside the point in any event because Mr. Metcalfe's intentions are not.
And I follow both what you say about 369 and you say it's beside the point. But how do you fit what you say about 369 with 372? When the tribunal says Mr. Metcalfe had not in fact been looking for any action.
If you read them together, the tribunal is saying he doesn't have any specific action in mind, but he appreciates that some action will be taken, perhaps, to the effect of a public statement. I think, if I can put it in these terms, what the tribunal is not saying that Mr. Metcalfe expected Garden Court to do nothing with this and that they would take no action upon it. The tribunal is saying he didn't have in mind any specific action, save that he had perhaps thought that one of the things they might do would be to make a public statement associating themselves from the claimant's views. Can I then just bring some focus to my submissions as a matter of statutory interpretation, how they fit within the scheme of Section 111? This is not, my submissions are not a matter of reading words into subsection 2 of Section 111. My submission is to this effect. Cause is to be given its ordinary meaning in law. The ordinary meaning in law, per Q8 Airlines, is that in addition to but-for causation, there will generally need to be additional features, or by Lord Justice Newey's formulation, which should be, the identification of which should be informed by what is fair and just and reasonable. But one has to identify particular features relevant to the particular cause of action rather than apply that general test in an open-ended way in every particular case. And per both Q8 Airlines and Bullimore, in the context of the Equality Act and Section 111(2), the additional features to be identified have to be done by reference to the purpose of the cause of action. Here, that is to prohibit things which have the characteristics of discrimination within the spheres to which the Act applies. And so the additional things are the characteristics of discrimination. So that's my...
And just put your
Go on.
and the characteristics of discrimination are
The character-
the influence point,
Yes,
and then I want you to talk to me certainly about the damage point,
yes,
what that means and who has to cause the damage.
yes. So the influence point I think I can leave. As I understand it, it's now common ground that on any view that there was a significant influence of the claimant's beliefs on Mr. Metcalfe's actions. The second aspect of direct discrimination, which is what we're concerned with, is less favourable treatment. And that entails both less favourable than somebody to who doesn't possess the relevant protected characteristic, and also in some way detrimental. And so the first part of that is easy. Quite obviously, Kieran Medcalf would not have written a complaint of this kind in respect of somebody who didn't possess and express the beliefs that the claimant was possessed and expressed.
That's the influence point, isn't it? What is less favourable? You keep calling it a complaint, but that's not what the tribunal called it. It called it a letter. KM would not have written what was less favourable about writing a letter about this claimant. Just that he wouldn't have written it at all.
He wouldn't have written it. So that's the easy bit. So that you compare the claimant with a hypothetical comparator who expressed some other view that Mr. Medcalf didn't object to. He wouldn't have made the complaint. So that's an easy bit. It does also entail, I accept, an aspect of detriment.
So what's that then? Detriment by A. It's not looking forward to the detriment that's ultimately caused by B to C. It's a detriment at the A stage. So
Yes.
the act of A, the
Yes.
causative act, needs in some way to cause damage or detriment in and of itself. Is that right?
No, that's not what I'm saying. So A's actions do not need to directly of themselves and independently of B's intervening actions cause detriment to C. A's actions merely need to be done in relation to C, and perhaps this is where I accept an element of reasonable foreseeability, or whether this is liable to lead to a particular outcome comes in circumstances where they are liable to, or may reasonably foreseeably result in detriment to C, including via B's actions.
Does that leave the innocent? I thought we talked yesterday about having to have some sense of culpability on the part of A, and that you could have an innocent actor who would not be caught under
Yes.
section 1112.
But I think it's probably my fault by using words like innocent and fault. It's really important not to use that language in an open-ended way. By that I was meaning in shorthand for actions which possess the characteristics of discrimination.
What concerns me is that you're nudging towards a strict liability of saying the moment there's a but for there, and so you've got the sequence established, and the action by A is significantly influenced by the protected characteristic.
Yes.
If something bad happens, brackets maybe there's some foreseeability attached to it, that is enough. A is in the ring.
I am nudging towards that, but that's not a strict liability because it has the mental element of direct discrimination attached to it. So
I'm sorry, I just haven't quite got it. I'm sure.
So this is the fundamental point about direct discrimination, is that it's not a question of whether what someone has done is reasonable, or even whether they might have a benign or laudable motive for it. If a person within the spheres to which the act applies does something because of a protected characteristic which causes detriment to someone else, someone to whom they owe the duty, that is enough to give rise to liability for direct discrimination.
Okay, I think I think there's not much difference between you, so I think it's only me that's out on a limb here, so that does happen from time to time. My next question then is, okay, but what next? Because it can't be that is sufficient. It may be that that's the, what am I trying to say? It can't be that that creates the liability or imposes the liability, because we know that there are tests around, the supervening events test. So there are occasions when, even though you could be liable, in fact, the outcome will be that you're not. A is not liable for what eventuates to C. We know that, don't we? Maybe supervening acts is the principle that gets you there. I don't know.
Well, in my submission, that there aren't in this case. So in my submission, it is enough that A acts because of a protected characteristic, I'm prepared, without saying it would always be necessary, to accept that it will generally be necessary for it to be reasonably foreseeable that A's actions may lead to detrimental action against C, and but for causation. And in my submission, those ingredients are sufficient by themselves, irrespective of any intervening acts.
So that is an absolutely core issue. Is there any role for a doctrine of novice actors, intervening acts, supervening cause, whatever, in this context?
Yes, that's a core issue. And if I could then just slightly step back from the absolutist position, it may be that I don't need to go so far, and this court doesn't need to go so far as to say there can never be an intervening act that breaks the chain of causation, because there may be things that I can't think of and the court can't think of that would obviously and sensibly break the chain of causation. It may be that the furthest I need go, and I certainly do go this far, is that nothing about the intervening acts of B can break the chain of causation.
Why not?
Because it is inherent in the structure of section 111 that there is an intervening, where the basic contravention does occur, so not an attempt, that that B has done something which is culpable in the discriminatory sense, which is because of the protected characteristic, and for which B is independently responsible and liable. So what section 111 it clearly and explicitly contemplates is that both A and B may be liable to C.
Yeah.
I have a suspicion that if one thought about it, one could come up with an example of that being pretty absurd, where there just was no sensible connection between what A does and what happens to C, even though there's a but-for cause. I mean, I don't know. Suppose A does something that causes B. I mean, A does something with the protected characteristic in mind. So we're over your first hurdle, and then it causes B to run out in front of a car that happens to be coming along too fast and knocks him over. He's then in hospital for some time. When he comes out of hospital, his mental state has changed and he does something. You see what I mean? You could come up with a situation where it just wouldn't make sense to say that but for was good enough.
I can see that, and that's why I say I perhaps don't need to go so far as to say there may never be an intervening cause, but the intervening cause there would not in fact be B's actions. That it would be this completely independent event of a bus hitting B.
But it would still in the end be B's action that caused the damage to C. It's just that you think, well, there's no sensible connection between what A does and what B does, even though there's a but-for cause, because you see what I mean?
Yeah, I do. So there may be a role to play for intervening acts, which are, but still, I think my answer to your lordship's hypothetical scenario would be that a necessary part of the causal chain there is an intervening act which has nothing to do with B. It might ultimately be B's acts that then result in discrimination to C, but the intervening act that potentially breaks the chain of causation in that hypothetical scenario is one that is nothing to do with either A's acts or B's acts. It's something entirely
I mean, it
independent.
just feels to me like it's very. I can see exactly why it's convenient to your case to say the intervening act can't have anything to do with B, but that's quite a novel introduction to the law of tort. That law of tort is very flexible. Or we've looked at Kuwait, the idea that all should be just and reasonable, and you get to the right answer, and all those things. why, as my lord said, why should we be restricted to looking at these acts, and why can't these acts be something which actually is the cause of what happened?
Well,
Why can't it extinguish whatever went on before?
perhaps two answers to that. First of all, I'm not proposing this as a general introduction to the law of tort.
We've got a right to judgment. Tell everybody else what the law of tort is.
Of course, but the answer is that this is as I put it yesterday, a specific and entirely unique novel cause of action.
Yes, so you've got to persuade us that section 1112 narrows these concepts consistently with the purpose of the statute. And I'm not really seeing it.
It narrows these concepts consistently with the statute because section 1115, well, section 112 itself contemplates B committing a basic contravention. And in order for B to commit a basic contravention in relation to direct discrimination, that must mean B independently acts in a way that is detrimental to C because of C's protected characteristic.
It's not the first inducing tort that's ever been. Inducing breach of contract has been around for years.
Yes, it has, but it has its own very specific rules, and this provision doesn't derive from that. It's, as I said, it's an amalgam and a development of a series of slightly differing provisions in the predecessor legislation, which differed as to the terms that they used, inducing, causing, etc., and various different terms differed as to the scope, differed as to the extent of enforcement. So, in light of For Women Scotland and the need to look at the Equality Act on its own terms, I'm not taking the court through all of the history of the legislation, but that's the answer. Is that this is not? It's not like the inducing breach of contract tort, where intention is an important concept. It's not like any other tort. It is a unique tort located within the Equality Act, and section 111(2) itself contemplates an intervening act by B.
So does it come to this, that you say it was not open to this employment tribunal to conclude that the email was the occasion of the report no more? It wasn't open to them to say that we don't think Stonewall caused Garden Court's basic contravention, because once those criteria are made out, QED, that's it.
Yes.
And if that's right, that doesn't seem to be the way the case was put, because the tribunal seemed to think it was open to them. They were there to decide the issue. But you're saying now it simply wasn't open them to reach that conclusion that they did at 377 if our interpretation of it, or if the interpretation of it, if Stonewall's interpretation of it is correct.
Yes.
It just wasn't open to them.
Yes, I do say that. If I develop the point a little bit, so section 111(2) expressly contemplates the intervening acts of B. So it cannot, within the structure of the section itself, be an intervening act that breaks the chain of causation that B thinks about and then acts upon the causative action relied on in a way that is discriminatory. So if you like, if there is a further limiting criterion here, it's whether objectively it was reasonably foreseeable that B may think about and act upon the causative action in that way. So
and what's the causative action? I need to remind myself what the tribunal said. we discussed it a bit earlier. Was it the fact of an investigation where nothing had, where the investigation had previously, I think, concluded with nothing to research further, or was it the mishandling of the investigation that led to the discriminatory outcome that she was asked to take down 2 tweets?
But what I mean by the causative action is Stonewall's complaint, and just
But
Well,
I'm
what's-
asking about
what's the-
detriment,
what's
I
so,
think.
the-
yeah, so the unlawful action, the basic contravention, was the partially upholding of the complaint.
The outcome,
It was the outcome,
not the fact of.
not the fact of.
And I can't remember if the tribunal looked at it, if we discussed it yesterday, I'm sorry. Was the outcome, the discriminatory outcome, was that reasonably foreseeable?
Yes,
Why?
because Kieran, I mean, if I just go right to the end, Kieran Medcalf was writing to Garden Court saying, your member is saying transphobic things on which are therefore inappropriate on the internet.
What you say he wanted all along, and he got it.
I'm not talking about intent. I'm just saying the very thing he was complaining about was the claimant's expressions of belief because of the beliefs, because of his prejudice about those beliefs, and it must therefore be reasonably foreseeable that Garden Court will think about and may uphold his complaint in those terms. And as I said, on the tribunal's findings, part of the reason they drew the inference was indeed that Garden Court, certain members of Garden Court, shared Kieran Medcalf's hostility to the claimant's beliefs.
Where does the fact as found come in that it was Garden Court's mishandling, as I've understood it, of this complaint that led to the discrimination? That layer of because some of the points we talked about were not forwarding documents, the wrong people getting involved, that sort of aspect.
Well, they don't. It's not quite right to say that they found that led to the discrimination. What they do is they make careful findings about all of the things that Garden Court did in the course of considering and deciding upon what to do about the complaint. And they were critical of some of those things, and their criticisms were part of the set of facts from which they inferred that the final outcome was because of the claimant's beliefs. So it's not right to say that they found that those things they were critical of led to the discrimination. Rather, they inferred from some of those things that the eventual outcome was because of the claimant's beliefs. And so if I can perhaps put it in these terms, because Garden Court is an organisation, its consideration and decision about the complaint necessarily has to involve a number of people and a process. But that doesn't make the communications between those people and the process they follow different in principle or different in character from what might all be done in an individual's head if this were a complaint to an individual and the individual were taking a decision by him or herself. So that all of the things that Ms. Omambala has pointed to as being potentially intervening acts, and it has to be said the tribunal hasn't done this exercise.
Or hasn't explained
Hasn't
this.
explained this exercise. All of the things that she's pointed to are part of the consideration of and decision about the complaint itself. That's the character of all of those steps. So in my submission, and this is perhaps, if you like, a further step back from my starting absolutist position, certainly and on any view in this case, there is nothing about the character of any of those things which is anything other than the intervening act of B in thinking about and taking the decision on the complaint, which is the cause of this this basic contravention. So my final fallback position, I hope I'm putting it clearly, and please tell me if I'm not, but my final fallback position is, even if intervening acts might sometimes break the chain of causation under section 111(2), and even if an intervening act of B itself might sometimes break the chain of causation under subsection 2, on any view in this case, the intervening acts cannot do so, because all they are is B doing the basic contravention. And as a matter of clear principle within the structure of section 111(2), B doing the basic contravention directly in reference to the thing that A has done cannot break the chain of causation. It's not clear to me whether it is now suggested that Kieran Medcalf's intentions, the just a protest characterisation, could be said to be a basis on which the tribunal did and properly could have found that section 111(2) wasn't made out. But can I just briefly address that in case that is still in play? Make sure I've got my submissions to your lordships and your ladyship clear. As I say, the subjective intentions of A, first of all, ought not in principle to be relevant. Two main reasons for that. One, the word cause in subsection 111(2) does not imply any intention. And secondly, as a matter of general principle in discrimination law, intention is not relevant. Therefore, not relevant whether Mr. Medcalf intended the complaint as just a protest. The only potential relevance of the just a protest description is if that were intended to indicate or go to in some way the question of reasonable foreseeability. But that question has to be considered objectively, not by reference to Mr. Medcalf's subjective intentions. The tribunal did not directly consider that objective question, although it did, as the tribunal has seen, recognise that it was certainly one possible interpretation of the complaint.
Well, actually, that's dealing on the different issue again, isn't it? When they say it's a possible interpretation, they're talking about the subjective intention.
Threat.
They are, but they are.
So then they don't, in terms, I think, ever deal with foreseeability.
No, they don't.
But their possibly one need look no further than the letter.
Well, precisely. We say there's only one possible answer, and I went through a lot of the material yesterday. I'm not going to treat your lordships and your ladyship to a rehash of the points, but could I just re-highlight the really key ones? First of all, as my lord indicates, there's the form and content of the letter itself, and just in response to something my ladyship said a short while ago, the tribunal does clearly identify it as a complaint. At page 132, there's the heading, the Stonewall's complaint, and
Right.
189.
You got me. Tell me again what the page was.
132. And secondly, I can't remember which of your lordships or ladyship it was that posed the question to my learned friend, but there was a question about whether there was any evidence about how Garden Court perceived the complaint. There was, I can't remember off the top of my head all of the detail of it, and I'm not sure it would take us further to trawl through it. The critical point, which is in my submission apparent and obvious from the tribunal's judgment, is not just that it was. They describe the complaint as Stonewall's complaint, but that is clearly how it was understood by Garden Court, because if you go to, for example, page 137, you have at paragraph 205 the considered view of Maya Sikand, having received and been given a copy of the complaint. On close examination, she decided it had to be dealt with as separate to the batch she'd already reviewed, because all the tweets now complained of predated the 22nd of October launch tweet. So it was plainly received and understood by Garden Court as a complaint about the claimant saying things that she ought not to be saying, which they needed to investigate.
The reference to complaint by Mr. Metcalfe comes again and again.
It does.
Paragraph 199, the important complaint. 200, we need to return to this complaint, and so on.
Yes.
At 376, they ask, was it in fact seen by Garden inducement?
They do, and their focus there is whether Garden Court thought that there was an explicit or implicit threat to their relations with Stonewall. But for present purposes, was it reasonably foreseeable objectively that Garden Court would consider and act upon the complaint in the kind of manner they did? Answer plainly yes, because it was sent in the form of a complaint. That really ought to be enough, but I'll just highlight a few further points. It wasn't just a complaint. It was a complaint sent by Mr. Metcalfe in his capacity as head of trans inclusion at an organisation that was hugely influential in this field on the tribunal's findings, that had built its reputation, representing the interests of lesbians like the Claimant, and was now branding her beliefs, the protected characteristic that is an issue in this case, branding those beliefs bigoted and transphobic and amounting to hate speech. And I took the court yesterday to passages in Miller and Higgs that demonstrate that that position is a prejudice about those beliefs like any other, like any prejudice about race or any prejudice about sexual orientation, because it's not true that those beliefs are bigoted and transphobic and hateful. And so coming from the head of trans inclusion to a member of their diversity champions scheme in a context where if you think back to the circumstances at the time, Stonewall was regarded as a respected organisation taking a moderate position that would be listened to and respected. And the tribunal had before it, and it's reflected throughout the findings, plenty of evidence that members of Garden Court shared Stonewall's position. So if one asked the question on the material before the tribunal and on the circumstances that applied at the time, was it reasonably foreseeable that Garden Court would receive a complaint from Stonewall, would think that it needed to investigate and make a decision about it, and may uphold it because of the very beliefs that Stonewall was expressly complaining about in that complaint? The answer is plainly yes. And so in my submission, that's the answer to my ladyship's concern that we're potentially moving to strict liability. The answer is not to look for whether B, in acting on the complaint, did something that was independently culpable, because that's inherent in the structure of the legislation. The answer, if we need a further control mechanism, is to be found in, was it reasonably foreseeable that B would do something of the kind that it did? Was that the sort of thing that was liable to be done in response to this? So as in Bullymore, the very sort of thing that an employer is likely to do on receiving a bad reference that refers to a previous discrimination complaint is victimise the person who is who that reference is about. And so here, the very kind of thing that anyone receiving a complaint about one of their members or employees is likely to do from an organisation like Stonewall is to investigate that complaint and decide whether to uphold it on the sorts of grounds that are identified in the complaint. And the sorts of grounds identified in this complaint were fundamentally discriminatory. They were fundamentally prejudiced. And that's also an answer to my ladyship's question from yesterday, that it's okay to express contrary to beliefs, and absolutely it is. But what it's not okay to do is express those contrary, those beliefs in a way that is tainted by prejudice, that makes untrue and prejudiced statements about a particular belief, and that is done in the context of a sphere to which the statute applies, not as a personal statement of belief or a personal contribution to the debate, but on behalf of an organisation within the sphere of the legislation to someone else covered by the sphere of the legislation. In a way that
would
is
the case be the same if Mr. Metcalfe or Stonewall had put out a press release just vehemently criticising Ms. Bailey's views in the same way as the 31st of October email does in the 7 or 8 particulars, but not addressed to Garden Court saying do something about it, do what's right. Just a statement. Would that be a breach of the Equality Act?
No.
So why not?
First of all, that would not be an action done within the context of a relationship to which the Act applies. So that would take it outside entirely. Because
Right, so they're still connected with each other in the same way. The factual connections are all still there. It's just a different mode of.
No, but that would be a statement to the public at large. That would not be a statement within the context of a particular relationship to which the statute applies. Just as in the employment context, if my boss makes a statement on Twitter that is perfectly lawful and proper within the confines of Twitter, but I find that an offensive thing for my boss to have said, that statement is still made outside the employment sphere, so is not something that I can complain of to my employer about my boss. So that's the first reason why it wouldn't. The second reason why it wouldn't is because it wouldn't be a complaint to Garden Court from which it would be reasonably foreseeable that Garden Court would take action.
Well, that would need to be the subject of a fact find,
That- it
because I
would,
mean that's
yes.
quite. And I have to say that my note to self on all of this is all just the sort of stuff you'd expect a tribunal to be looking at, the reasonable foreseeability of actions and so on. But you may say to me there's nothing there, but I don't think the tribunal was asked to look at this, was it? Reasonable foreseeability.
No, I mean, I confess that our case, and it's still a case to this court, was that it's obvious that if you make a complaint, it's obvious that that complaint is liable to be investigated and may be upheld for the sorts of reasons that you've tried to put forward in the complaint itself. And if I don't want to sort of be snipey about it, but it wasn't for me to raise reasonable foreseeability as a potential barrier. If it was to be said that it wasn't reasonably foreseeable that Garden Court would treat Stonewall's complaint in the way that it did, that was for Stonewall to pursue. In my submission, if I can draw the threads together, my primary case is it's enough that you have action because of the protected characteristic, but for causation, and without saying that it will always be necessary. In most cases, I accept it's likely to be necessary to have some reasonable foreseeability.
The reasonable foreseeability of some detriment.
Reasonable foreseeability of
As
some
Professor Lang illustrates, it may be much worse than you had anticipated.
Yes,
but
exactly that. And that there is no other intervening act that may break the chain of causation. I step slightly back from that. There may be exceptional cases, kind of my lord indicated, where a completely independent cause intervenes. But I find it difficult to conceive of any instance where, absent that, any actions of B's can amount to an intervening cause. Certainly not any action which is no more than part of the consideration of the causative action of A and part of B's intervening basic contravention itself, because that would be contrary to the structure of the legislation. And on the facts of this case, it's conceded that significant influence is made out. It's conceded that but-for causation is made out. In my submission, there's only one possible answer to reasonable foreseeability for the reasons I've given. But if I'm wrong about that, then, as my ladyship says, it would have to go back to the tribunal. Would your lordship and your ladyship give me 1 moment?
Oh, yes, sorry, I'll just check my list. Yeah, I think I've got this.
Two sets of complaints.
My lord, my lady, could I just, in case the court hasn't got the point firmly in mind, my learned friend said at one point that there was already an investigation ongoing, so that the Stonewall complaint didn't trigger the investigation. I think I took you through yesterday the chronology, and it is clear that the first part of the investigation had concluded in relation to quite a number of complaints that there was nothing in them. Then the Stonewall complaint comes in, and then it's that complaint that Garden Court run with, and that results in the discriminatory act by Garden Court, hence the but-for causation, and hence they clearly were responding to that as a complaint.
Yes, I think that's right, isn't it? Ms. Sickhand was just about to sign off saying no further action on the 31st of October. Email means that things continue.
Yes, exactly. Given that. And to underline the point, the claimant was only asked to respond to the Stonewall complaint. So it was that complaint alone that led to any investigation in relation to her that she had to respond to or engage with. Unless I can assist the court further, those are my suggestions.
Very much.
My lord, sorry.
Yes.
My lords, just if I made 2 tiny points of detail. I'm grateful. In relation to the detriment question that's been posed on a number of occasions, and my learned friend said it was a dissociation from Garden Court dissociating themselves from the claimant was identified as the detriment. Simply that at page 124, paragraph 155, the tribunal sees that detriment has already taken place in relation to the response tweet.
The response tweet is 24th of October.
Yes.
So it doesn't flow from Mr. Makeup. I think we.
What paragraph was that?
That was paragraph 155.
Thank you.
And just finally, my learned friend spoke about the actions of B as an organisation and said that it wasn't a case of individuals acting. Of course, these were barristers named as, I think there were 119, and in respect of whom there were particular allegations for some of them. So just a note of caution, I wouldn't want the tribunal to think that
Right.
that it was a monolith.
Thank you. We will of course reserve judgment. We're very grateful to both sides. We have been saying to each other throughout this day and a half that the oral advocacy on each side has been very high quality. It doesn't always happen in this court, but it has happened in this case. So we're very appreciative. We're also appreciative of the backup work by both teams. When we have reached a decision, we'll send out the draft in the usual way. As counsel know, as indeed I'm sure the appellant as a barrister knows, the draft is sent out not for the case to be re-argued, but for correction of obvious factual errors, typos and so on. It's also confidential to the parties and their legal advisors until the formal hand down. Any consequential matters should be dealt with in writing. I think that's everything. Thank you all very much.
Court rise if able.